Thank you, folks. Have a seat. All right. Good morning. We're here in state of Arizona versus Sean David Rix. It is 1 CR22 0305. We're here for oral argument. Counsel, each side will have 20 minutes to argue their points. We will argue from the podium. You'll see the clocks on the podium. They do show the time counting down. And counsel, if you choose to reserve any time for rebuttal, you will have to keep track of that on your own. We don't subtract that from your clock. So folks know we have read the briefs very carefully and reviewed the record in the case. We've also pre-conferenced the case earlier this morning, so we are very familiar with the record and the argument that you folks have presented. So I would ask that you focus your arguments today on what you think is critical and not simply restate the brief. I think you both know that, so we appreciate that. We also appreciate you taking the time to be here today. I know that we set this on our own because we felt it was important to hear argument in this case. You do have the 20 minutes. You're not obligated to use all of it, but certainly use the time you feel that you need. We are recording and broadcasting these proceedings, so when you do approach the podium, please state your name and the party you represent for the record. Counsel, if you're ready.
Thank you. Kristen Curry, appearing on behalf of the appellant, Mr. Rix. You directed that we focus our argument today on the 404C1 categories. Under the rule, the court can only admit the evidence of the other acts if it finds that all three categories are satisfied. I'd like to jump to category C because that's the primary category here where the court abused its discretion in this case.
Does that mean that you agree that B is completely fulfilled?
Not necessarily.
Okay.
I do believe, and I could quickly go through that, I do believe that there was sufficient evidence under category A based upon the trial court evidence that came in to believe that these devices belong to him. As for category B, I will address that as part of my argument. But going to C, the court is to find the evidentiary value of the proof of the other act is not substantially outweighed by the danger of unfair prejudice, confusion of issues, or other factors. And there's a laundry list of factors that the court is supposed to go through. Now, the judge in the case went through the factors listed, and it simply supported his view of the relevancy and evidentiary value that he felt that those factors had. But what the court failed to do in this case is discuss anything about prejudice or do the balancing act. There was nothing in his ruling that discussed prejudice at all. There was nothing that went through the balancing of the probative value versus the danger of unfair prejudice. In looking at some of the findings of the court, in particular,
just okay. So do you disagree that there was at least some relevance? And relevance is, of course, there is no such thing as some relevance, that these were relevant.
Under some of the categories they did, but I disagree that they had relevance under all of the categories to allow their admissibility.
And which ones do you disagree?
Specifically looking at the category of whether this was a similar or a dissimilar act. The court found that this was similar because it involved underage females, and the images portrayed underage females, girls' genitalia, or portrayed them in sex acts. Well, that is not what this case was about. This case was about an adult going on an adult website, which was strictly for adults, to communicate with adults. And he placed an ad on this adult website, and the ad indicated that he was looking for adults.
And got into a conversation with someone who clearly said, I'm 13.
That is true. But in this case, that's not similar to downloading pornography from the internet. And there was no evidence presented in this case at all that anything that was on the devices was from a email chat, was from any type of text messaging directly with the person.
Let's be clear, because the nature of the charge is not possession of child pornography, correct? The nature of the charge is solicitation to obtain exploitive material.
Attempted.
Yeah.
Right. But the attempted...
Do you agree with me that those are different?
Well, the charge was attempted solicitation of the photograph.
Right. Okay. So in other words, we're not talking about possessing child pornography here.
That's correct. We're not. And in fact, there was no images of pornography even exchanged in the case. Okay, so we're talking about the state having to prove that the defendant believed he was actually talking to a 13-year-old. That's what one of the elements is required to prove. Not simply that a person says, I'm 13 behind the screen, but that he believed he was talking to a 13-year-old.
And I don't dispute that, but I mean, that becomes then a fact question, right? We don't crawl inside people's heads. We prove that by circumstantial evidence.
Right, that is a fact question for the jury, okay?
Correct.
But that doesn't make it similar.
The jury found.
Right.
And the second part of that is that he was trying to get exploitive materials, correct?
Well, they have to prove that he believed he was asking a 13-year-old for exploitive materials.
Aren't these at least relevant to the idea that he wanted exploitive materials? He had to argue that he at least had some exploitive materials or show he had exploitive materials on his own computer?
Well, I think you also have to look at the fact that what site he was on. He was not asking for minors. He was not seeking out minors.
But he at that point when he, and I think part of this may go to whether or not his request on one of them was in fact asking for exploitive materials. There were two requests, and one of them was a little bit bigger. I think that's a fair statement than the second one. But my point is, they are exploitive. Isn't the issue that they're dissimilar? They're not the same kind of exploitive materials that he was asking for.
It is dissimilar, I think, because of the factual nature of what was happening there. But I think also because of the photographs that were allowed in the case as well by the court.
So how are they dissimilar?
Okay.
Tell me what makes them dissimilar.
Well,
I have my thoughts, but I want to hear yours.
If you look at what was asked for in the original ad, okay, to photograph adult women's vaginas. All right. Then there was this discussion by email of whether or not 13 was okay, et cetera, et cetera. But the problem is the other act evidence didn't just show minor children's vaginas. They showed unbelievably outrageous conduct, bestiality. They showed sex acts between children and adults. The majority of the pictures that were admitted in this case were those type of acts.
Does the fact that he asked a 13-year-old versus a prepubescent child, and some of the images, at least, well, by the testimony, involve prepubescent children?
I do think that makes a difference. I do think that makes a difference because they actually went, some of the photographs, they talk a lot about prepubescent. At one point, the detective even said, well, this one's even a toddler. And then that's, yes, potentially a toddler. So that's the kind of evidence that the court let in the case.
Do you disagree that if the court let in only images of the exploitive exhibition of, say, a 13-year-old female's genitalia, that would be okay and acceptably similar? Would you accept that proposition or not?
Even if they could determine whether it was a 13-year-old or not, I think everybody knows that 13-year-olds have different development.
That sort of fights the hypothetical. I'm asking, my question assumes the truth of what I'm asking. Assume for the sake of discussion you have 6 images, which happens to be the number of the exploitive exhibition images that were introduced in this case, I think. Let's say there were 6 images that were spot on for the right age of the undercover. Do you agree that that would be similar under C1C and thus proper to seek to admit?
I don't, because I still think the probative value is outweighed by the danger of unfair prejudice.
But it would be far less prejudicial than images, at least, of bestiality in toddlers and sex acts, since he didn't seek any of those things from the undercover, right?
Sure, absolutely.
Okay.
I think it's going to be less, but it's still, in my opinion, overly prejudicial. And if you even look at some of the things that were testified to in the case, the majority of the case was spent on these other acts, not on the underlying charge itself. And the forensic examiner, the computer forensic examiner, Matthew Trafford, the first thing he testified about was watching a video. We're seeing a video of a child about 10 years old performing oral sex on a dog. That's what he talked about. He also testified that there was over 3,000 images of child sex abuse material on one of the items, item 10, and on another item, 2 videos and 97 images of child sex abuse material.
Are you arguing that the sheer testimony itself that these items were on his devices is too prejudicial? Is
Absolutely, that coupled with the images themselves. Because if you look at the evidentiary hearing transcripts, the judge never reviewed 3,100 pictures that they've alleged. In the first hearing, they sort of stopped the hearing, and the state said that they were going to reduce the amount of pictures to about 50 or see what they could do. In that hearing, however, there was a discussion about allowing the state to just talk about how many items they found, even if they didn't show them.
Well, isn't the purpose of 404C really to talk about propensity, and isn't number of or quantity of a particular substance involved, or number, a quantity of prior acts involving that are directly related to the crime charged? Isn't that relevant?
Well, then you're basically saying it's unlimited, it's an all or nothing proposition, and the courts have not said it's an all or nothing proposition.
Isn't that when we get into the prejudice issue? You know, that some appear to be okay. I can't say that that's a clear statement by our courts, but that all, depending on the number, is probably not okay.
That's what the courts say, that there has to be some sort of, if they think anything's probative, they still have to go through and decide which ones can be put into the case because of the issue of the danger of unfair prejudice. And the court just didn't do this at all. They didn't do this analysis at all. And in fact, they seem to say, well, you know, the state on the first August hearing was basically, I'd like to put in all 3,000. And the court said, well, you know, that's going to take a lot of time, but if that's the way you're going to do it. And then the state decided, well, I guess I'll pare it down. But the state still wanted to be able to say that there was over 3,000 images. And the court in that hearing indicated the court felt very uncomfortable with doing that. That's what he stated. But then the issue was never addressed in the October hearing and was never addressed in the ruling. The state simply did it, and without anybody stopping them.
Counsel, would you agree that throwing the 23 or so photos up on a board is significantly more prejudicial than abstract knowledge of the number of photos? Would you agree those images are more impactful?
Well, they are, but when you're coupling them together.
Okay, so yeah, just stay with me, please.
Okay.
So follow up on that. How long was the period of time that the jury was subjected to the 23 images graphically in court? How long did that take?
I believe it was probably around an hour and a half to 2 hours.
An hour and a half to 2 hours of
that particular testimony.
Of the visual display accompanied by state testimony of the 21 to 23 images.
And basically from the trial counsel's, my conversation with trial counsel, they also put them up during Mr. Rix's testimony.
Okay, so it's repeated during Rix's testimony, about maybe an hour and a half during the direct examination of the state's own witness, and then how long during Rix's testimony?
But throughout cross-examination.
Okay,
so
maybe the jury's looking at these things for over 2 hours, conservatively.
Probably a little more, but yes. The trial was only 2 days.
Sure.
So, and they were on a big display, approximately a 55-inch screen that was sitting above the witness's head. So, and then as the picture came up, Mark Hoyt, who was the retired detective, described what was in the picture as it was being shown on this large screen television. Now, this case of State versus Salazar, which 181 Arizona 87, the court indicated there's not this all or nothing proposition, that there's an incremental inquiry that may be divided into three different parts. The first, whether the probative value should be admitted in some form. Second, what restrictions to place in jury instructions. Third, whether the evidence could be narrowed or limited to protect the parties by minimizing the potential for unfair prejudice, but still preserving that probative value. And that's what the trial court just didn't do at all. They just didn't even analyze it at all. The only thing that the court even said about the exhibit that was admitted was that 2 videos couldn't be shown. But they said it not because of the prejudicial nature of them, but because of a disclosure issue. These kind of pictures are outrageous. They were meant to be inflammatory in this case. They were meant to horrify the jurors in this case. And because more time was spent on those, and the facts of this case.
Well, counsel, it seems like it was an extraordinary amount of time spent on the other act evidence in a 2-day jury trial.
Yes.
Especially on a jury trial that had nothing to do with actual child pornography or examining these exploitive images for whatever reason beyond 404.
That's correct. There was just, because there was no images even exchanged in the underlying charge. And they picked out the worst of the worst. I mean, they didn't even pick out pictures of just genitalia of a 13-year-old or anything like that. They picked out horrible, deplorable type sex acts of children in bestiality and also with adults. And that's what they showed, and that's what they talked about. And they talked about 3,000 other pictures. This was just a sampling.
Well, he had the other 3,000, didn't he?
I'm sorry?
The other 3,000, they weren't wrong to say the 3,000 existed.
Well, the trial counsel could only review them by going there and quickly looking through them together. They weren't able to have a copy of them, so they weren't able to see exactly. And the judge didn't see it either.
But we understand your position about the existence of the number, but, I mean, there were an awful lot of these images on Rix's devices, obviously. That's not really the issue here. The issue is throwing up 23 of them, 15 of them extraordinarily graphic for 2 hours to this Mojave County jury. That's the issue, isn't it?
I think that's the issue, but also then coupling that with saying he had 3,000 more of these.
But he did, didn't he?
I'm not saying he didn't or did. Unfortunately, the judge didn't know whether he did or didn't because the judge didn't look at all of the images. He only looked at the 50 or so that were put in the second hearing.
If he did, I don't want to use up your rebuttal time, but I mean, to the point of Judge Faria's question, I mean, doesn't that go to the strength of the inference we draw under, a trial court would draw and we would see drawn under C1B, because it's about the strength of the propensity. I mean, 3,000 images is more of an aberrant propensity than one probably, right?
Absolutely.
Okay.
But then the problem is the danger of the unfair prejudice. And that's really what this case is about, is the danger of the unfair prejudice. And, in this particular case, the issue was, did he believe he was talking to a 13-year-old? And without that other act evidence, there was a chance that they could believe him on that. There was a chance that he could believe because of the circumstances of being on an adult site. Even the photos that were exchanged, they were of a face. They weren't of a body, and he didn't believe them to look like a 13-year-old. But with that other act evidence, that horrible inflammatory act evidence, it was likely the jurors' repulsion prevailed here, and they based their belief that the state proved the element rather than basing it on the actual elements of the offense. We're asking that you find that the court abused its discretion in this area, reverse the convictions, remand the case for a new trial. Thank you.
And I hope I'm not talking to her.
You're good.
Perfect. Good morning, Your Honors. May it please the Court. Andrew Riley, appearing on behalf of the state in this matter. To clarify, or I guess I'll just jump right into the main issue. And while I don't necessarily doubt that it felt like 2 hours, if we look at the actual description it's the March 16th transcript, the descriptions cover 9 pages out of a 250-page transcript. So that would have to be a very slow-talking 2 hours in describing the images. And when I read that section of those 9 pages, and it's pages 210 to 219, essentially, when they're doing the images, it's presented in a very clinical and very professional way as best you can with this type of material.
You're talking about the detective's testimony, not when they were up during Rix's cross-examination.
No, and I apologize. I don't have those pages on that. But again, that was more of the prosecutor put up specific images and said, "Does this person look like a girl, or, a young girl?" And he would combat that. But to the prosecutor's discretion in that, even in the cross-examination, she didn't talk about the image from the cell phone, the bestiality image. So it's not as though she had the opportunity to do it, to present it again and show it, but she didn't do it. So there wasn't this focusing directly on the most graphic aspects of it. And to that idea that image is somehow so much more abhorrent than an adult male having sex with a child. That argument wasn't raised below, so there wasn't the opportunity to counter that or any sort of so a claim of that, as opposed to the way I read, and if I was mistaken, I apologize, but the way I read the argument on appeal and below was a generic all or nothing. You can't present this stuff because you can't present any of this stuff, and then after the judge says no, there's enough evidence here that he possessed it, knowingly possessed it, that it relates to the aberrant sexual propensity to commit the charged offenses, and it's not outweighed.
So are you saying that if they object to the introduction of the photographs, then they basically haven't preserved their objection to, if you throw up 23 gratuitously unrelated ones, that they somehow have failed to preserve the issue at all? Is that what you're saying?
Not the general issue, but for a specific claim, it's for a specific issue, that this issue is somehow so much more graphic or so much more abhorrent. So
they have to say no photos, and then they also have to say, and not these 50, and not these 23, and not a dog, and not oral sex. They have to say all those things individually, separately, or they've waived, is what you're saying.
For an individual one, yeah, for like a bestiality, the way I view it is in like autopsy photos. If I just generally object to 20 autopsy photos because I agree, we agree that this is how the defendant died, and then on appeal they say, well, this one's really, really nasty because of that. Well, that argument wasn't raised below.
But if they said all of them are too bad, they can get more specific on appeal. I mean, they have presented it to the court.
I would say they presented the general one, and the way because again, there's other ways, if that was really the issue. The counsel didn't have the general objection. She made a general objection to the cell phone and saying, well, I just don't want the two images that are the same image of the bestiality image. If she had said that that's, so much worse. And the reason why I say that is because there's other reasons why it's why that image specifically would be important. One, it's the only image, it was a video actually, and they didn't introduce the video, they introduced thumbnail image, but it was the only illicit image that was on the cell phone. And it being on a cell phone that is in his possession when he's arrested is evidence that he knowingly possessed this thing.
Well, why introduce the image at all? I mean, is there a dispute that he owned the cell phone? I mean, you have ownership images. I mean, what is the legitimate evidentiary purpose in showing child bestiality in this case from an evidentiary standpoint?
Because he has all these images on 4 different devices, so he's knowingly possessing this stuff. The bestiality, and again, if there had been the initial...
But counsel, we just established that sheer possession of child pornography was not the charge. What was the charge?
Attempting to get more child pornography.
No, it's solicitation of exploitive images, is it not?
Yeah, attempted to get additional child pornographic images, yes. So the fact that he possesses thousands of images on over multiple devices in his house and on his person is relevant. And so the idea that if you were to kick out the bestiality picture, since that's the only image on his cell phone, you're misrepresenting essentially to the jury that he only had these images on 3 on 3 devices, when he actually had it on 4 devices, one being his phone, and important to note too, that the bestiality image, one of the main complaints below, or the main arguments below, was the remoteness of the child pornography versus the emails in this case. Well, the bestiality image was downloaded and on his phone just 4 days after the second conversation.
Well, counsel, I think your argument with respect is inconsistent with Salazar, because there are ways to demonstrate to the jury that the image is owned without the graphic display of the image, correct?
Yes.
Okay, so it didn't need to be shown to the jury to establish that the image was on the cell phone, right?
Correct.
Okay, and an officer could have testified in the trial below that there were images cast at whatever level of generality the trial judge deemed appropriate. Could have said child pornography, could have said exploitive exhibition, could have said child sexual activity. The court could have done any of those intermediate things to narrowly tailor this, right?
Correct, but it wasn't asked to. The defense didn't raise that objection, or even raise the
defense asked the court to decide whether or not this was unduly prejudicial.
All of it.
And in doing that, the court has an obligation, doesn't it, to make sure that whatever it does under those circumstances is not unduly prejudicial.
Yes, but the argument needs to be made. There was in the pleading below, in the response below to the 404C motion, was a general 403 that that says the undue prejudice, wasting of time, and it covered everything. There was no specific objection to the image itself or the graphic nature of the image. It was just that there was 2 of them.
Okay, so we understand that your position is it's not preserved, and you've explained it very well, the state's position. So let's go to the substance of it, assuming that's not so.
Okay.
So let's talk about C1, C2, similarity or dissimilarity. Do you contend that the bestiality image of the young child fellating the dog is similar within the sense of C2? Is that similar such that it should be admitted for relevance, or is it more dissimilar than an exploitive exhibition photograph?
I think it satisfies the similarity. I obviously agree that a simple exploitive exhibition photograph is directly on point, is completely analogous. But again, this is sex abuse. This sex abuse of a minor, of a young child, and that was.
So sure, no, I get you, counsel. So from the point of view of your argument, there are these like hideous images of an adult manipulating the genitalia of seemingly a toddler, and then you could hypothecate an image of a nude 17-year-old girl. In your argument's cosmos, those are equivalent for purposes of this analysis, correct?
Not equivalent, but similar enough, yes.
Well, but they're
not so dissimilar that it would outweigh the relevance of it and the probative value of it for being offered for the proper purpose as it was.
Well, so you're answering my next question too. So you're saying they're both similar for purposes of C1, C2, and you're saying that they're both non-prejudicial in the same way.
Yes.
Okay.
So if he had asked a 17-year-old for a photograph, they could have put up pictures of infants on his phone, and you would say that that's not prejudicial.
I mean, again,
You're saying it's not dissimilar.
I'm saying it's not unfairly prejudicial. Again, the old cliche that all this evidence is prejudicial, but yeah, under the continuum, that it's not unfairly prejudicial.
So any photo he had, as long as it involved a child, no matter how gruesome or whatever, it's not going to be unfairly prejudicial from what I hear from you. So there is no 404 and 3. I'm saying there's 403 analysis to be done in this situation.
No, there would always be the analysis. There is the analysis to be done. But again, I don't think it goes to something that it wouldn't necessarily automatically rise to a level of unfair prejudice.
So let's talk about the facts of this case. We have an image where the officer's own testimony was, it is a very young child, possibly a toddler, and he thought he was communicating with a 13-year-old. Tell me in this case why a possible toddler image is not unfairly prejudicial when he's talking to what he believes to be a post-pubescent female.
I don't believe it's unfairly prejudicial because the standard again, under 404C, is if, and under the B, is if there's a reasonable inference that can raise to the level where the guy has an...
No, because the unfairly prejudicial is independent. Yes, you get A. You get the reasonable inference. Now, why is showing what he concedes is possibly the image of a toddler's vagina being manipulated by what appears to be an adult man, when he is simply asked, and I'm not condoning this, I think everyone understands that, but his request was to see an image of a teenager's vagina. How is that not unfairly prejudicial?
Because like all things in that 443 context, or when we're judging whether something is unfairly prejudicial, a lot of times that really turns on the low level of relevancy of the particular evidence. This is very high level of relevancy on the defendant's aberrant sexual propensity to seek out child sex abuse materials, and that's what we have here. In addition, in the second conversation, again, excuse my language, but he also said, "Do you like sucking?" So, I mean, there's more involved here, and the point is to prove that.
But he wasn't charged with soliciting a sex act. So,
No, because
so this isn't another act in that sense.
No, I know, but it's. I would never. I mean, his defense was, I would never engage in that, and I would never want a picture of a young girl like that. Well, you got thousands of these images, so.
I'd like to follow up on Judge Goss's question and concept, if I could here. So basically, relevance and prejudice can be cumulative in relation to what's already admitted, right?
Sure.
Okay, so let's say that we agree with you and not with opposing counsel that it's totally fine to tell the jury there's 3,000 images, that's not unreasonable because it's information as opposed to a slideshow. And let's say that we also say that all the images of exploitive exhibition suffice to establish a showing under C1B. We think that wasn't an abuse of discretion either. We say, okay, that's reasonable because you're showing some examples, and we're not going to try to suggest you can't show any examples. But once you get to that point where you've already made the showing under A, there's other acts, the jury knows there's 3,000. You get to B, and the jury knows that there's these really disgusting, icky, gross pictures, and you get to show the ones that are most similar. What is the cumulative relevance of the most I should say offensive ones, and I guess here's the thing. This is the thing I feel like your argument isn't taking account of. In Salazar, we referred back to another case called Harvey, and there's a lot of cases like Harvey out there that basically say that the prosecution is kind of trolling and trying to arouse disgust when you get to things like human waste, sadomasochism, bestiality. It's partly that it's logically unrelated. Your argument doesn't seem to take account of that there are some things that are inherently super offensive. Can you comment on that?
I mean, this is inherently super offensive conduct. I mean, conduct. So there's no sanitizing it at that point. So I get the sadomasochist kind of stuff and things of that sort. Obviously not bestiality, but the things that are legal, clearly that's prejudicial in the sense that it's legal and it might be off-putting to others. But you can't be. But I mean, it can't be held against you that you engage in legal conduct. None of this is legal conduct. He's entirely intending to possess illegal conduct. And again, like I said, with this.
I'm sorry.
So it's all horrible and it's all illegal. So the analysis collapses no matter what. That's kind of what I'm hearing. Like there's no distinctions.
Again, it doesn't. I guess it gets to the point where what number's too much. I mean, I could agree that. I mean, I don't. That is the count that I had, and I could be wrong on it, but that they discussed right around 20 images, or
23 were shown, we believe.
Okay, so if whether or not 20 would have been better or 25 would have been okay, or I mean, I don't know where that spectrum is. I agree. There does get to a point where it's all cumulative, and so what that point is, I don't know, but again, there was the original objection to obviously the original thumb drive that had the 3,000 images, and I think part of the confusion is because the differing jurisdictions and the fact that you had this retired detective that couldn't, that's where I think some of these, technical problems just kind of happened by happenstance, where a detective that wasn't associated with the crime is kind of trying to put together this stuff in a legal fashion. So to answer your honest question, I don't know, and what that number is. But what I think is related to that number is the amount of devices that you have. Again, there's one illicit item or one set of illicit items on the phone, but it's important and relevant that he has this item on his phone that everybody keeps with them at all times.
I agree with you. I agree with you. And I think showing some limited number, I understand it to be professionally normal and appropriate in this area of prosecution, and I don't understand our questions to be questioning that proposition in any sense. It's that you already get to show 6 or 8 exploitive exhibition photos, so we get it. He has that. You've told them there's 3,000, and then the next 15 are in what I'll call the radioactive category. And that's the part I was trying to elicit the response, to see if you would engage the idea that there's something inherently prejudicial and meaningfully different about the radioactive ones. Once you already get to say there's 3,000, you already get to show 6 or 8 exploitive exhibition photos, so we see what he's doing. The last 15, isn't that the hardest part of your argument? Do you have anything specific you can shore that up with?
I mean, no, other than, and I don't, I concede that obviously the government response that you have with these things, but we have that in a lot of cases, whether it's autopsy photos, whether it's rape. I mean, so, and we entrust juries, particularly in criminal cases, even in civil cases. You see terrible, horrible things, and you agree, or the jurors come in and are properly instructed, and the evidence is relevant and proffered for its proper purpose and proper reason. There wasn't any inappropriate argument. It wasn't. It didn't even stray on the line.
We're not arguing that there was a proper purpose, and we're not asking you to address that. What we're getting at is, when does it go too far? Because the court's also obligated, when asked, to say that piece goes too far. And we've already established he's not on trial for possessing any of this. And in fact, this court never decided, and Arizona will never decide, whether or not it was illegal for him to possess it, because that's a Nevada issue. And it seems to me that's the challenge. Did we have a prosecutor who sought to introduce a lot of evidence as if the prosecutor was pushing the child pornography case, as opposed to the attempt to secure the erotic images? And in doing so, went too far.
I don't think so, Your Honor. I think the problem with the original thumb drive is, again, you're dealing with a jurisdiction that you just every couple weeks, the detectives comes by with the thumb drive. Could she have communicated better to the detective and pared it down initially? And should have that happened? Sure, of course. But again, the numbers, and I guess to answer the Honor's question, I don't know what that number is, and I don't think that there is an answer to that number. You have out of the 23 images, should you have only had maybe 5 images on the laptop and on each laptop?
No, I understand Judge Goss's question to be more about the relative vileness of what's going on here. So if I understand your position right, and I understand the state's position correctly, it's that because it's all child porn, it's all equally vile, and therefore none is more prejudicial than any other. Is that a fair summation of your argument?
And yes, in this case, I mean, again, in addition, the state had to prove that it was him, or that he was communicating and he believed.
So there's no more prejudice to showing a toddler's exhibition or exploitive exhibition picture than a 15-year-old's or 17-year-old's. There's no qualitative difference in potential for prejudice between those two images. Is that the state's position?
No, not that there would always be, but in this case, that there isn't. And again, my particularly frustrating is that none of this was raised below. So when you have 8 images taken and you're complaining of 8,
but people are entitled to a trial and to be convicted not because of emotion, bias, or prejudice. Is that correct?
Of course.
And that's a constitutional right, is that not?
Of course.
Okay, so if they are convicted on the basis of bias, prejudice, or emotion, okay, for sake of argument, that would be fundamental error, would it not?
It would if that happened. And I would just ask, as I rush through the last 30 seconds here. I mean, again, my point is, it's like if the defense attorney had said, hey, don't put this image, I don't like this image, put this image from the laptop, then you would have had that discussion. Then you could have had that discussion, but you just don't have that here under these circumstances. And as a last point, for what it's worth, the parties involved knew what they were doing. I mean, obviously it's toxic. This is obviously terrible stuff. And I just urge any sort of prejudice analysis, this court to look at voir dire. Voir dire was done particularly well in this case, and anybody who was going to have any sort of objection to looking at images or had any prior prior kind of experience with that was quickly excused because they knew of what they were dealing with. And so,
Can I ask one more question?
Sure.
Yeah, thanks. Apologies. Just so I'm trying to find a limiting principle, so I'll just ask it to you open-endedly, because that's what depositions you're supposed to do, is ask the open-ended question, not the specific one. So what is the limiting point here from your point of view as counsel for the state? Where, in a case like this, could prejudice ensue? Can you construct a hypothetical that would ring the bell under C1C, or does nothing?
prejudice would ensue primarily with like a improper argument, unnecessarily keeping, focusing on these images for an extended period of time, not 9 pages in a transcript of a 250-page transcript, or making improper arguments. Sure. No, I don't mean to interrupt, but just as a point too, in the state's closing arguments, they didn't mention the image in the first initial closing argument. So it clearly wasn't the import of the case that has been offered today.
I take your point, counsel. It's an excellent point, and certainly there are ways to misuse evidence once it's admitted. C1, which is what we ask you both to address, as a threshold matter, talks about the court shall admit only if it finds. So we're talking about the threshold consideration of whether to admit. And so my question, perhaps better focused, I apologize for casting my net more generally, is under what circumstances, hypothetically, would you ever see in a case like this the admission of evidence would ring the bell under C1C? It would be too prejudicial. Is there such a case that you can imagine?
On like a single image or a number of images? I mean, that's...
Mm-hmm. Like if we're trying to write an opinion that suggests what the limiting principle is, I'm just asking your help.
It's too fact intensive. I mean, two fact intensive again, because you have it's relevant on 4 different devices, and you have to introduce the evidence from the different devices. It's relevant on the comparison of the images on the device. I mean, again, there's I don't have a limiting factor. 50 images. I mean, again, it depends on how many devices. But for this case, 20 images spread over 4 devices that he regularly used, and I would say no.
Thank you for taking a run at a very hard, open-ended question, counsel. I appreciate it.
But I'm going to use my opportunity now. So, counsel, what do we do with the fact that the court never told us why? Because you're saying it's fact-intensive, and we don't know that the court ever engaged in the prejudice discussion. There's no analysis. So how do we handle that in this circumstance when, as you've acknowledged, it's an intensely factual situation, that it does involve the analysis of each photograph, and that didn't happen here?
On the record, it didn't happen here because, again, it wasn't asked to do it individually. It was asked to do it as a group. And so I think we view it as this group, 23 images over the course of 4, under the facts of this case, as it was presented, 23 images over the course of 4 devices, and their relevance as that.
And we don't know why the court found them not to be prejudicial, unfairly prejudicial. We just don't know.
Or he tried to, from what he was offered, he did the analysis on the lack of remoteness and the possession, that he didn't actually knowingly possess these things, because those were the things that were raised. But yes, defense counsel has to raise these on an individual photo basis, an individual device basis.
A final question, which is your point about not being raised. So essentially you're saying if we do anything with it, it should at least be under a fundamental error analysis, not harmless. Isn't that what the difference is?
If we were to do a specific analysis on an individual photo, that such photo is so graphic or so toxic, then yes, that would be
And your position is it should be fundamental error. Did you say that in the brief?
I did not, because again, I didn't know.
But your argument is that everything she argued in the opening brief really shouldn't have passed that.
Yes, because again, I'm viewing it as a whole. I'm not individual sticks, okay. Right? And so if I welcome supplemental briefing on that. Again, if that was my mistake, if we're going to do an individual, like an individual photo is so egregious, or an individual amount from an individual device is too many or so egregious, I'd respectfully ask the opportunity to brief that as opposed to just the bundle of sticks. And I'm sorry for going way over. We asked.
We ask.
Yeah, thank you.
Anything further?
So we'd ask that you affirm the conviction sentence. Thank you.
What we'll do is add 4 minutes. I've been keeping track of the time. I hit my little timer to make sure that we were fair. So, counsel, if you want to wait until we get the time, you can walk up. I just don't start until we get the timer adjusted. but that way everybody gets the same amount of time. Now, the trick is, can I figure out how to stop the timer so it doesn't beep on you? I don't know that I'm going to. I did.
That's
Yeah, we're still adjusting.
Okay, thank you.
I think we need to go another 15 seconds. There we go.
Counsel, can you please start with preservation? That seems to be a major thrust of the state's position here.
I do think it was preserved in this particular case. The defense attorney filed a motion, a response to the state's motion objecting to all of the photos. She argued about that in the evidentiary hearing. She also argued against any testimony related to the number of images that were on the device. I don't think she has to go through each and every picture and make a separate objection because she objected to all of them as being overly prejudicial. One of the things that Judge Gass brought up is the issue of, was the prosecutor pushing a child pornography case rather than really the charged case? And it seemed like the prosecutor was. Basically by the photos that were chosen, by wanting to talk about how many photos were on there. And in fact, in the closing argument, the rebuttal closing argument, she said, how many children need to be victimized? What this detective did prevented a real child from being trafficked or victimized. She emphasized again that this was not all of the images, just a sampling, and the defendant wanted to increase his collection of child sex abuse material.
And counsel, wasn't there also, I mean, it wasn't published to the jury, but there was a photo of a fully clothed prepubescent girl with a shirt that said, I heart CP. Wasn't that something that was taken back for deliberation? But
I don't know,
truthfully. But my question, okay. If you don't know.
So, just the nature of some of the photographs and the description of the photographs, there has to be a difference between just genitalia and something so graphic and disgusting and horrible. People are going to react to that, and it seemed that the state definitely wanted this jury to be horrified and disgusted.
So do you think there's a qualitative difference in terms of creating prejudice in a jury between what we would call the exploitive exhibition photos of, say, a 13-year-old female's genitalia and what I was calling the radioactive photos in the colloquy we just had? Do you see a very significant difference or not?
And it does depend on the particular facts of the case. The defense position is that none of them should have been admitted because they were overly prejudicial based upon the facts of this case. But the court had a duty to go through this and look at prejudice, and it just didn't at all. It didn't limit them. Pretty much if the state put it on the thumb drive, it was allowed in. There was no discussion at all why this particular one should be in and this one shouldn't be in. There was no discussion at all, and the court had a duty to do that. The bottom line is this was not a fair trial for Mr. Rix because of these photographs. He did not get a fair trial.
So the preservation occurred at the original hearing and through the original motion practice, and not through reassertion at each individual image.
I don't think a person has to object to each image in trial if they've already objected. They haven't waived that. They don't need to do that because sometimes they don't want to do it because it's in front of a jury and they just don't want to emphasize the fact over and over.
Well, and they'd lose every objection.
Correct.
That might
right, correct. So I think they have preserved that, and it is there, and because the trial court failed to even conduct any type of prejudice analysis, I think it has to be remanded for a new trial. Thank you.
All right. Thank you. We appreciate you folks, again, being here today. We appreciate the focus of the argument. Again, we had pre-conferenced it, and we are going to take the matter under advisement now. We will issue our ruling in due course. And with that, we're going to stand adjourned. Thank you, folks.